Hi guys, today I would like to talk about contingency fees in family law. Typically, contingency fee is where a lawyer takes percentage of the amount the client received from the other side. For example, in personal injury case where client doesn't have money to pursue the claim, lawyers have this agreement about 30 to 44% of contingency fee, whatever we collect from the other side, minus expenses. So let's say $1 million is collected, expenses $100,000. From $900,000, the lawyer gets whatever they agree, 30 to 44%, and then a client gets the rest. So that's called contingency. Why it is discouraged in family law? Well, first of all, a client who cannot afford attorney's fees, there is a code section, need-based attorney's fees, Family Code Section 2030, where a client can request attorney's fees to be paid by the other side. And in domestic relations, a lawyer might be in a position of conflict of interest. Imagine a situation where a client wants to buy out the other side, and because they want to buy out from the home they live in, they want the home value to be as low as possible, to give less money to the other side. But the lawyer who collects from the total amount of assets wants the value to be as high as possible. So obviously there is a conflict of interest that lawyer-client have at this moment that is discouraged by public policy. Also, a client who is going through divorce might reconcile with the other side, and a lawyer who depends on the fees doesn't want that. And so it will promote dissolution more than reconciliation, which is also against public policy. So that's why contingency fee is discouraged in family law cases and criminal cases. Well, I'm not going to talk about why in criminal cases because I'm only focusing on family law cases. Now, in post-judgment proceeding in family law, the reconciliation is not an option anymore because they're already divorced, so that's no problem. And it's possible to have contingency agreement on post-judgment proceedings. Also, completely not okay to have a contingency agreement at the initiation of divorce proceeding because reconciliation is still possible. In cases where the lawyer joins already ongoing divorce where it has been filed, reconciliation doesn't appear to be possible, there is asset split division prepared. In that case, it is possible to have contingency agreement when all of these points that we just described are met. Okay, and finally, support arrears calculation. So obviously, there is, when support arrears, when the lawyer says, I'm going to collect a percentage of spousal support arrears, that is also not a problem because all of the above concerns do not apply to this post because they're not going to reconcile when there is spousal support arrears pending. They might, but it's unlikely. And the amount is fixed, so there is no incentive for the lawyer. Actually, for both of them, the client and the lawyer, there is an incentive that support amount is higher, so there is no conflict of interest, and it doesn't promote dissolution because support arrears already. It's not a typical situation where support arrears in the support arrears situation, the spouses will reconcile. So still a very touchy topic, as you can tell, because it has a lot of moments, unpredictable moments. So probably the safest way to have contingency agreement in post-divorce judgment proceedings. So that's all for today's video. I hope that was helpful, and I will see you soon. Bye.